Hi, lovies. Very few things in life would have me so worked up that I'd be streaming at 10:19 p.m. on a Wednesday evening. But today has done just that. We have our emotional support mic ready to rock and roll. We're going to be punching Proctors, and we've got multiple strings of pearls to be clutching. Are you ready for what I believe will be the best shot that we have seen in the United States of America for Karen Reed and her defense team today, pulling out all the stops, providing shocking information to the court. And the ball is now in Judge Beverly Cannoni's in her court. And she must make the decision that we all know she needs to. All right, let's get these pearls on and let's friggin' go. Oh, tell me, how are you? How are you today? Okay, let me find where I am. Hi, lovies. Hi, MCAT. Let's fucking go. Oh, Juan, I'm saying it. I'm saying it. I'm not spraying it. But we are about to get our socks actually rocked directly off of our bodies by the one and only Alan Jackson. I'm excited. Oh, Maisie Daisy says, let's go. Oh, and Haywoods, you blow me, says, let's fuck. Are we fucking? Oh, we are. Oh, Maddie Wags. Hi, Lovey, says, thank God you're on. I've been passing away. Love, brilliant you and these lovies in the chat. Oh, listen to me. The brilliance came today in the form of our bearded non-dragon, but he is, okay? Is he a bearded dragon? I think he is. The fire that was brought today, 5 alarm. Just wanted to tell you, wanted to remind you, babes, who told you? Was it me? When I said get your popcorn ready, I didn't realize that we'd be jiffy popping out of our seats. Didn't know it was coming, but it came. And the way I clutched and clenched today shall not be replicated in life moving forward. Because, I mean, the strength and the muscles that we have is unmatched. I'm just saying there, okay? All right, here's Kim Pearls. Next one. Let's rock. Oh, and a little lippy gloss. Put on some gloss for good luck. Oh, who is she? Oh, throw a little color. All right. We're ready, babes. Tell me everything. Shock and horror. I felt you. I felt your name today, babes, right? Hello. I was out of my mind. Full blown out of my tits. Extraterrestrial left my body. This guy. Oh, where is he? Let's hide this. Sorry, shock and horror. This little bald tramp. Okay. Chippy Proctor, you got some explaining to do. And we're only going to do the afternoon, and we're going to listen to the entirety of Alan Jackson's just Hiroshima in Norfolk Superior. When I tell you guys that I had a dream, this was what I had the dream about. This was it. And I knew it. Now, was I there yesterday? Absolutely. Are we going to talk about the body language of one Hank Francis Brennan? And what a difference a day makes, babes. Oh, your tone changed quite a bit, Hanky boy. Didn't it? Would have loved to see your face. Now, we're going to have to talk all the shit with who? Our girl, the only Nan. I need to know everything. I need to know I need to know facial expressions. Like, we need to know all the shit. We're gonna find it out. We could also ask Will Viglera, but he's a boy and he probably didn't pay attention. But I know Nan will not have let us down. Oh, oh. Retired detective file says evisceration. Okay, let's go. I'm about to burst.
Inverted video. In the moving papers, the prosecution indicates that, quote, the prosecutor had not previously received this video or knew of its existence. This is I don't know if it's the third or the fourth time that the Commonwealth sort of runs through this argument about not knowing personally about the existence of a particular video, but that it doesn't matter how many times they argue that point, it still doesn't change the fact that it prejudiced the defense by not having it, and one of their members, whoever that agent is of the Commonwealth, was lying about having it and not disclosing it. Somebody knew, and the question before the court is, who was it? Who did know? Perhaps it wasn't Mr. Lally, perhaps it wasn't Ms. McLaughlin. Was it Chief Rafferty? Certainly Proctor had it. He watched it. Who else knew about it? Members of the prosecution knew the existence of this and other videos, and they hid them, and that's the galling issue. Then the Commonwealth writes that the defense altered, their word, the defense, quote, altered evidence to correct the image, as if we were altering something to deceive the court. When in point of fact, the Commonwealth well knows that that altered video was altered by them in some way, shape, form, or fashion. When it was played inverted. What we did is recorrect it to the proper orientation to confront Sergeant Buchanan with it. They indicate that they played the entirety of the video, of the corrected video, to somehow suggest that the Commonwealth during this debacle had clean hands. And that's just not true. Over the course of 2 days, the court will recall 2 days worth of testimony. Day one with Sergeant Buchanan under direct examination by Mr. Lally, going into the next day, still under direct examination by Mr. Lally. They played that video completely inverted. They talked about it, they discussed it, they described it. Not once did Sergeant Buchanan or Mr. Lally inform the jurors or the court that the video was actually altered, that the video was actually backward. Not one hint to the court or the jury members. When the defense stood up and began questioning Sergeant Buchanan about that video, that was the first time that he admitted that it was inverted. He used the phrase mirror image, and that he knew that it was inverted. Amazingly, that was the same time that Sergeant Buchanan started having trouble with his memory about who was actually depicted in that video. The court will recall before I stood up on cross-examination, under direct examination by Mr. Lally, Sergeant Buchanan was very quick to point out that the individuals on that inverted video were himself and Michael Proctor. And they made the point that Michael Proctor never approached or had any access to or didn't manipulate in some way, shape, form, or fashion. This was the intimation by the Commonwealth, that passenger taillight. The Commonwealth has now conceded that that person was in fact Michael Proctor. It's notable that the Commonwealth went to great lengths to state that, quote, Trooper Proctor, and this is in their opposition, Trooper Proctor is standing feet away from the defendant's vehicle and never touched the right rear taillight, end quote. That's a statement made in their moving papers, specifically on a fact that is of great material importance to this case.
Yes.
The three of them signed, the three prosecutors signed an oath and a declaration, and the court just called the defense out on signing a declaration or.
Oh, I'm sorry. We're fucking, says Alan Jackson. This is the moment. When I heard this live, guys, I said, oh, no, he didn't. No, he isn't. Is he going to say that the court has accused, one side, the defense, that you are all responsible for any document that is signed, right? Well, documents were signed by the Commonwealth. And Trooper Michael Proctor is the extension of the Commonwealth and the prosecution. And we will hear Hank Brennan later on go into detail about how he had nothing to do with, the prosecutors and Adam Lally and Ms. McLaughlin, but that is incorrect by law. So take them to church, AJ, on this fucking, pardon me, sorry. God forgive me. on this Ash Wednesday, we were taken to church, and it was by the one and only Action Jackson.
Oath. And the court's intimation, at least in its initial comments to me, was, you may have said something that you don't have a factual foundation for. I think I have done my best to disabuse the court of that we were drawing from reasonable inferences. I wonder if the Commonwealth is going to get the same treatment for saying that Trooper Proctor was standing feet away from the defendant's vehicle and never touched the right rear taillight. That's a very bold statement for the Commonwealth to make, and it's also completely untrue. It's not supported by a single fact. It's not supported by a fact or evidence before the court. The problem with this unsupported motion, because it's unsupported and the declaration is signed by 3 different individuals, you can just sort of say whatever you want in the motion. I guess get away with it. The video speaks for itself, Your Honor. It shows Michael Proctor walk behind the car directly to the position of the passenger taillight. He positions himself right on the other side of the camera view, not feet away. And it certainly does not show, and there's no evidence before the court that he, quote, never touched it. As a matter of fact, we would submit.
Does it show that he does touch it?
Well, of course it doesn't show.
Oh.
So he's on the other side of the car.
Oh, and Judge Cannoni, babe, all right? Remember, as we refer to her from here and forth, it shall be Polly Pocket Bev, okay? What the Christ are you asking in this very moment, ma'am? If there was evidence that Trooper Proctor had actually physically touched that taillight, do you not think that that would be everywhere that we could put it? I'd be putting it on flyers around, okay? I'd be putting it up on telephone poles. Proctor touching taillights. That's assault.
That's not the point. The point is, a reasonable inference is he could have touched it. He was standing right there. Nobody forced him. Nobody was holding a gun to his head. He walked around the other side of the car and obviously was standing there for a reason. By himself, in a corner, out of the view of a camera. And then when the Commonwealth plays the video, it switched. And the intimation to the triers of fact was he never approached the right rear taillight, that passenger taillight. And all of that.
And you cleared that up.
Right. But that is the galling part of this entire thing. The court has asked me a couple of times, and I'm going to get to a little bit more in detail what the prejudice is. If that's not prejudice, I don't know what is. It's literally propounding false information to a trier of fact. That is not a small thing. Even after the trial was over, it was concluded, and the mistrial was declared, we're still getting videos that we can't get a straight answer about their source. Where did these videos come from in October? That surveillance feed is on a 30-day deletion loop. That's what we've been told.
Oh. Now keep this in mind, babes. The 30-day deletion loop that has been shoved down our throat since the origin of us getting the Sally Port video in the middle of or at the end, rather, in June of 2024 during trial. Okay? 30-day loop. Let's see about that.
I said a few minutes ago this morning, I said the Commonwealth may not have known that it was on a 30-day loop. What I meant was actually the prosecutor sitting in this courtroom. The 3, my brothers and sister, may not have known about that 30-day override. I don't know. I don't know what they knew or didn't. I'm certainly not going to cast aspersions and put that on them. But someone from the Commonwealth darn sure knew that was on a 30-day loop or a 30-day override. So who's had those for all this time? How were they stored? Why wasn't that information revealed to our expert when we went all the way to Canton to try to download that DVR? Where's the original?
Where is
Where are
it?
the copies? These are questions for which we need some facts.
Yes.
And the fact that those have been withheld from us is exactly the kind of bad act and bad faith that demands that the court presume prejudice in the case. A few minutes ago, the court asked me before lunch, what is the prejudice? There's plenty of actual prejudice, but I'll get to that in just a second when I speak a little bit about the law at the end of my comments. We don't need to prove actual prejudice because the law presumes prejudice against Ms. Reed because of the bad conduct on behalf of the Commonwealth. And yet again, when it comes to this Same issue. The Commonwealth recites this now worn out sentence: the prosecutor was unaware of the existence of these videos, end quote. How many times are they going to try to excuse away a blatant discovery and or Brady violation with the sentence that the prosecutor was unaware? It just doesn't matter.
It
And that brings us
doesn't.
to the October 10 videos that we got in 2024. The Commonwealth claims that they received these videos on or about August 21st, 2024. They sort of
Oops. Oops. He did it again. Bum, bum. Here it is. The Commonwealth alleged they got video in August of 2024, but they didn't turn it over to the defense until October. How come? Why? Oh, I don't know. Let's do it for the first time tonight because it won't be the last. On your mark, get set, punch a Proctor.
vaguely claim that these videos were provided along with a letter, quote unquote, letter from Canton Police Chief, end quote. There's no report, there's no email, there's no communications, there's no text message, nothing other than this quote letter. And it actually wasn't a letter. It was more of an informal note written on a personal pad, a Canton PD pad by the chief. There's no chain of custody log.
Oh my God.
Authenticating the videos, no authentication documents whatsoever, no foundational documents, no indication of where the videos came from or how she came to possess them at the time. But she did write on that little pad, quote, that is how it records, LOL, no tampering, end quote.
Oh.
LOL, laugh out loud.
Well, thank you for that clarification, AJ. Giving us that street slang of LOL. Look at Kat looking back and going, oh, Chief Rafferty. And Kelly, if Chloe bit you must have quit, you're absolutely correct. Is there something funny, Chief Rafferty?
So the chief of police is laughing in the face of serious Brady violations, in the face of serious evidentiary violations
And
and
what was the
discovery
date?
violations.
10/10/24 you received that?
Oh.
Was that the date?
10/10/24. That's correct. By the way, the Commonwealth claimed in its opposition papers that, quote, the prosecutor requested that both Massachusetts State Police and Canton Police Department produce all relevant and material surveillance video, end quote. And that was sometime unidentified between April 17th, 2024 and April 24th, 2024. I laud them for that. Good. I'm glad they demanded finally, in the middle of trial, quote, all relevant and material surveillance video. So why didn't we get this from Canton PD until October 2024, well after trial? What was the delay? And why did we get another video in January of 2025? What was the delay? How could this be seen as anything other than intentional? We know now that Sergeant Buchanan, we know that Proctor, we know that Chief Rafferty, and now through another report, we know that this officer, B.G. and Petro, all had access to and knew about the videos. And then we have on top of that, in the middle of trial, I think it was Mr. Lally, it may have been Mr. McLaughlin, someone said, it's unclear from the opposition, that all relevant material surveillance video be turned over immediately, and it still wasn't done. That is an intentional withholding of evidence.
Sure
And
is.
then we get these new reports. What's probably most troubling is what's in the reports that we got on Friday.
Oh, okay. Babes, if any of you are new here, hi, I'm Nurse Kim. And the information you are about to hear was unknown to all of us before Friday, last Friday. Okay? This is mind blowing. Our queen, Eliza Little, did so much work over the weekend, and so did the entire team. But to sift through this new discovery dump from the motherfucking Commonwealth of Massachusetts and what they came up with is the best case scenario, in my opinion, for Karen. And this completely changes the argument in the motion to dismiss. Now, prior, I thought it was a strong motion to dismiss, but I also know who sits on that bench. I know that Polly Pocket is not going to make any decisions that are negative or shed any negativity on Mass State Police or the Commonwealth. Your bias is showing, Beverly, and it shows frequently. But now, gathering what AJ is about to tell us changes everything.
This past Friday. Additional reports from in a report from Sergeant DGM Petro, he reveals the following. He writes this report on the 27th, which was last Thursday, and then we got the report on the 28th. He says that in February of 2022, and I'm paraphrasing, in February of 2022, Proctor requested Sallyport video of SUV inside Sallyport. Apparently that was provided. I mean, we have to presume from his report when he says Proctor requested in February of 2022 Sallyport video of the SUV exterior footage that he downloaded it from somewhere and gave it to him. Assuming it was February of 2022, that would have been before the override, I presume, because I think the math in my head is 28 days in February. If it's in February at all, it's within the 30 days from January 29th. So it has to have been. Then he writes that in June of 2023, Proctor requested Sallyport video again of the SUV exterior footage. Quote, this is from his report. I believe this may also have been the approximate time that I downloaded video recordings that covered the entire time frame that the suspect's vehicle was held at the Canton police station, end quote. He goes on to say, quote, due to the large size of the files at that time, I had to break it down into 6-hour blocks for ease of exporting. This is the first we're hearing of any of this last Thursday.
Friday. Okay, now, okay. Did you hear that, babes? Did you hear that? Because we had always questioned, what do you mean? What are you telling me? That how is it possible we continue to get these small snippets of information and video recordings from an event that took place in January of 2022 when you keep shoving it up our poop shoots that there is a 30-day deletion loop, right? Allegedly. Well, the retired police sergeant whose cloud of unknown origin held this information was not only downloaded back in February of 2022, but there was so much video footage, guys, that it had to be sectioned into 6-hour increments. Bitch. Tell me more, AJ.
How is that?
And our queen
Sure.
gives
Ms.
the
Lynn just handed
document.
me a clean copy of the DGM Petro report. I would like to have this marked and appended to our motion to dismiss if it's okay.
Sure. Did I get that attached to your motion to change the scheduling?
Yes. You probably did.
So I've seen it.
Okay. May I approach it?
Hold on. What, Ms. Little?
We'd still like to make it part of the record if
Sure.
all right, Your Honor.
I just wanted to know whether I needed a copy because I have a copy. I've seen it.
May I approach it?
Yes.
Okay.
So are we marking it? So we need it if we're marking it.
Yeah, we're marking
Sorry,
that.
my mistake.
Exhibit 1, so mark. Okay. Go ahead, Mr. Jackson.
Thank you, Your Honor. The question is, how in June of 2023,
Ooh,
now I'm going to go a little bit slow here just because it's
please.
linear. The argument is linear. In June of 2023, according to DGM Petro, he downloaded every single bit of video of that car while in the Sallyport, while at Canton PD in Sallyport. How is that possible? How could that be? As of February 28th or maybe March 1st, those videos are gone. So how could he have access to the whole thing? It's because someone at the Commonwealth downloaded the whole thing. They saved it. Or the only other explanation is that DVR was not at the time on a 30-day override. It's the only explanations. Again, this is binary. So in April of 2024, as the court knows, we got additional video, and that's the inverted video. In the spring of 2024, while trial was being held, DGM Petro, quote, it says, quote, I downloaded some video recordings that you and I believed may be needed to refute claims being made by the defense. The you and I is him to Chief Rafferty. That's who this report is to. And it includes footage of Higgins.
Okay. Hi, lovies. At this moment, my eye begins to twitch. So you're telling me that the newly retired DG Giampietro, he and Helena Rafferty, the chief of police, the active chief of police in Canton, Massachusetts, decided to parse through the video footage in which this sergeant, his cloud, and all the little people who may have decided to take a little look-see at this by the time that the trial had occurred in April of 2024, they decided that this is the moment we must look through things to refute Karen Reed's claims. I'm sorry. You decided to take more snippets and to fuck with, tamper, and withhold evidence from the defense more? Oh, ho, ho.
So now we find out for the first time that Chief Rafferty and this sergeant had been talking and strategizing about how to defeat some defense arguments, presumably, by use of videos that had never been turned over. And the Commonwealth uses a phrase in its moving papers, I believe in this motion, about ambush. That is the definition of an ambush.
Oh,
So DG Petro admits that he, Rafferty, and the Canton Police Department had Sally Port video that was material to the case. Remember, his quote was that you and I believed may be needed to refute claims made by the defense. They were strategizing about how to defeat certain of our arguments, and they didn't turn it over. Specifically, he downloaded video and presumably gave it to Chief Rafferty. But then the interesting thing is Chief Rafferty held on to it. She never turned it over.
Oh.
Probably because they didn't help the prosecution. They showed Higgins
Exactly.
engaged in conduct that is, at the very least, highly suspicious and clearly exculpatory because it impeaches his other testimony. It shows.
Now, remember, babes, just for any of us who are not attorneys, exculpatory is not just evidence proving that, that would be beneficial to Karen from a clear picture, right? Or clear video footage. Impeachment evidence, meaning that you are able to prove that what was said by Brian Higgins on the stand, ATF agent Higgins, from after drinking how many Jameson and gingers, going down to New York, coming back, going to the hillside, hitting up waterfall afterwards, and going to a house party, decided he wanted to go and play musical cars with government issued vehicles at Canton Police Department at 1:30 in the morning. He has been full of shit since day one. And then in October of 2024, the defense team got actual footage of him on a cell phone, not dialing with his ass.
On the phone.
Fuckers.
And he testified that he didn't make calls in the middle of the night. There's no question that with this example, that is an intentional withholding of evidence. That is the legal definition of bad faith, and it's unconscionable to do that. Now put in context what we eventually did receive during the trial and then after. We received the inverted video that was falsely presented as the right passenger side of the vehicle, or the passenger rear side of the vehicle. Number two, we received several videos of Brian Higgins at Canton Police Department, clearly using his phone at approximately 1:35 or so a.m. And we received exterior footage that would ordinarily show the condition of the passenger taillight, which all happens to be corrupted, like every other video of the rear passenger side of that SUV. This is stunning. It's not like the Canton.
Corrupted like Norfolk DA office, corrupted like Mass State Police, corrupted like the Commonwealth.
Police Department and the Massachusetts State Police were sort of blissfully incompetent or blissfully ignorant and unaware of the existence of these exculpatory videos. It's quite the opposite. Multiple officers, Proctor, Rafferty, Buchnick, O'Rourke, DG and Petro, these individuals, we believe, O'Rourke may not have known, but we know that the others did, and have now basically admitted it or been caught trying to hide it. They were all variously actively engaged with these videos. They were searched for, they were discussed, They downloaded them, they saved them, they copied them, they labeled them, they transported them, they reviewed them, and they strategized about them. These videos were top of mind for all of these folks. We know there were hours and hours and hours of footage that was so large it had to be broken down into 6-hour blocks. All of that was pulled. And none of this footage was disclosed to the defense before April of 2024. And most of the files that have been turned over so far have been turned over after the trial was over. We had no idea this footage existed, and to this day, it continues to be, the bulk of it continues to be withheld from the defense. And then we move to Sergeant Buchnick's actual report. As I indicated, he wrote a report last Friday as well, dated the 28th. Quote, in furtherance of the John O'Keefe Canton homicide investigation, sometime in early spring of 2022, I was made aware that a request had been made by Trooper Proctor and then fulfilled by Canton PD for surveillance video as it related to the arrival and storage of the Lexus SUV belonging to Karen Reed. This was the spring of 2022, he knew. At Trooper Proctor's request, I proceeded to Canton Police and picked up the digital media storage containing said video and transported it to the Canton, Norfolk District Attorney's Office and turned it over to Trooper Proctor. I did not review this video at this time.
What date did he do that? The same date?
He says at this time, but it's the sometime early spring of 2022. That's the best he can do in his report. Paragraph 2, in July of 2023, so this is a little more defined, I was once again made aware by Trooper Proctor that a request had been made to Canton PD for additional video and that it was ready to be picked up. Since the Canton Police Department is conveniently located on my route of travel to work, I stopped by and picked up the CD from the front desk of the police department, which was labeled Trooper Buchanan with a yellow Post-it note. I further added,
Like Romy and Michelle's high school reunion, we label things with Post-it notes. And you know what? I fucking invented them. Oh, I have something in my pocket for you, Buchnick. And I was able to find it right here.
Canton PD 12922, and then the case number, which is, or their case number, 2022-112-33, to note to more accurately identify the item and transported it to our office, subsequently turning it over to Trooper Proctor. So there's a second CD, now in July of 2023. I did not review that video at that time. See the attached copy of the Post-it note. Final paragraph, in my preparation for trial in May of 2024, I was provided with a thumb drive and the CD labeled with a Post-it note on my desk. What's interesting is that the CD with the Post-it note on his desk may or may not have been the same CD that he transported in July of 23 because they seem to be labeled a little different.
So I haven't seen this report. Does he say from whom he received that?
I'll finish reading it, but I don't believe he does. No, it's pretty vague. It's passive voice and it's pretty vague. I was provided a thumb drive and a CD labeled with a Post-it on my desk to review prior to testimony. So it does not say. At this time, I reviewed video made available to me, which included video footage of the Canton PD exterior Sally Port. This video was labeled with a Post-it note on a CD, and it contained a video of the interior of the Sally Port, which was grainy and had a camera vantage point from the front of the Sally Port. I also reviewed the Canton PD driveway footage. In review, I also viewed video of the back wall Sally Port camera vantage point. I had not seen this video prior to my May date review. I later learned that this video was provided in an inverted manner. After I reviewed all the provided video, the thumb drive and the CD were returned. It doesn't say to whom they were returned. Your Honor, if I could mark this report as well.
Sure. Do you have an extra copy for me?
I do. It does.
How scary is it too, babes? Like to just really actually think of this. Now, I challenge anyone who may not believe what I believe, right? Even if you do not like Karen Reed, even if you do not believe that there is enough for whatever reason to believe she is not guilty, that she is innocent in the death of Officer John O'Keefe, I challenge you to look at this injustice and the inability to do the right thing by a Commonwealth and a prosecution team and a bench, Polly Pocket, and see all of this occurring and not think that if it was you or someone you loved in this same position, how the fuck you would feel. I guarantee it will make you start to second guess things in this case. This was the watershed moment, I believe, that was needed. And this is a free and our Karen Reed.
It does have one highlight on it. May I show it to Mr. Brennan?
Yes. So you do have an extra copy, Ms. Little?
I do not have an extra copy, Your Honor.
I thought Mr. Jackson just said he had an extra.
Oh, I'm sorry.
Yeah. Mr. Jackson, do you have an extra copy?
I think I might.
I've got it right here.
You have an extra copy? Is that one clean? Almost.
You go, Ms. Little.
No. That was the only copy that I got.
May I approach, Your Honor?
This one has highlights on it. I apologize.
It's okay. Thank you. All right, go ahead.
Thank you, Your Honor. The court asked probably the most important question about this report, which is, who was it that supplied the video or the thumb drives or the CDs to Sergeant Buchanan? Who's at the center of all these Sallyport videos? Who does he say was
Who?
requesting the Sallyport videos that he was acting as the courier for in other particulars? Every one of
Who?
those answers is Michael Proctor. So who do we believe most reasonably would have supplied the information to Sergeant Buchanan to review? It stands to reason could have been Trooper Proctor. Seems to be reasonable, but I don't know because Trooper Buchanan doesn't say. But that would be another question that would be open to answer if we had an evidentiary hearing.
Which we demand.
Michael Proctor was receiving the footage directly from DG and Petro, dating all the way back to February of 2022. He was the one receiving the footage directly from Buchanan, dating all the way back to the spring of 2022. Michael Proctor was receiving footage from both sources multiple times through the years. Proctor was the one who clearly had possession, custody, and control over the exculpatory footage. It was his, every bit of it. And now let's recall what he said at trial when asked about all this footage, because he was confronted about footage. And keep in mind, Your Honor, when I'm asking these questions, I know none of this, none of it. Michael Proctor lied during his testimony, but he knew that we couldn't impeach him. There's no way I could impeach him. I didn't have any of these videos to impeach him with because we didn't have any of the evidence that had been secured concerning that Sallyport. Question, there's surveillance video from Canton Police Department's Sallyport garage that wasn't turned over, right? Answer, that video was discovered later on and then handed over. That video was discovered later on.
So where in the transcript is that?
I can get you the page and line number, Your Honor.
My guess is Ms. Little can get it pretty quickly.
I'm guessing
I'll
she
provide that to you
can.
in just a moment, Your Honor.
June 10th.
It was either June 10th or June 12th, but let me double check.
While she's looking for that, Your Honor, may I
Please go
proceed?
ahead. Yep.
Okay. The only thing it's important to remember from a date standpoint, we'll get the date that he actually testified to this, but from a date standpoint, the only thing that had been handed over at the time that he testified to that was a single video with 42 minutes missing and a flatbed and the flatbed driveway footage outside the Sallyport that doesn't show much of anything. It's now been proven, that testimony, that video was discovered later on and then handed over, suggesting there was either only one video or all of it was discovered later and turned over. Both of the clauses in that sentence are a lie.
Yes.
The video wasn't discovered later. It was discovered in February, at the latest, February of 2022, just days after this incident. He asked for it and he
Yes.
received it, according to Sergeant DG and Petro. And it wasn't turned over either.
And babes, I just want to ask you one thing. And I want you to really think about this. Trooper Proctor requested this video in February of 2022. Now, let me make myself a little bigger to drop a truth bomb that we all know. Okay? Why would Trooper Michael Proctor request video from Canton Police Department all areas. I mean, he asked for everything, babes. He wanted the hallways, he wanted the front door, he wanted the driveway, he wanted every angle of the Sally Port in which he requested Karen Reed's vehicle to be transported to, and not to go to another Mass State Police location that would have been closer when returning her vehicle on a flatbed, right? From Dighton in a fucking blizzard. Now, I'm going to give us a hint. I do not believe that Adam Lally knew shit about shit because why? He's got shit for brains. But Trooper Proctor knew exactly what he was doing, exactly what he was requesting, and why. I'm going to bring us back to David Yanetti's opening line in Trial 1. Karen Reed was framed.
None of it. But at trial, we didn't have the truth. I couldn't impeach him with this. He made sure that all the footage was delivered directly to him starting days after this incident. And he controlled it, he hid it, and then he lied about it. That is the definition of bad faith. That is the definition of withholding exculpatory evidence. That is the definition of suppressing Brady evidence. There is no other way to define this. He fooled us, and it's egregious.
Love
Is
the
it
word.
possible with all this sort of years-long flurry that we've just talked about surrounding these Sally Port videos, that the actual trial prosecutors were completely unaware of their existence until Proctor testified before the federal grand jury? Is that possible? I suppose it is. I want to give the prosecutors the benefit of the doubt. I do. Is it reasonable? That's another question. To believe that they just knew nothing about this. We know Proctor lied to us. Could he have lied to them? I suppose. But as the law mandates, Your Honor, it just doesn't matter. In the eyes of the law, Proctor is the prosecution, and the prosecution is Michael Proctor. And then we move to January 28th, 2025, this year. We're still getting additional videos at that time. This new camera angle, which is blurry and grainy and wobbly, it does, however, show the passenger side rear taillight as it's towed into or driven into the Sally Port garage. The footage is so grainy and so blurry, however, it's so corrupted that once again, the true condition of that taillight is completely obscured. At a certain point, it begins to defy logic. And the reason I wanted to talk about each one of these videos in turn is because it absolutely defies logic that all of this footage magically cuts out, blurs out, becomes grainy, becomes obscured at the precise time that the SUV is pulled in to the Sally Port. The question then becomes, what's been happening to these videos that have been in Michael Proctor's possession since that time, for the last 2.5, 3 years? Again, I've lost count how many times the Commonwealth makes the claim, quote, prosecutors have never seen this video, end quote.
Never.
The entirety of the Commonwealth's defense on this issue is the indefensible, which is, it just wasn't me. Okay, fine, it may not have been you, but it was the Commonwealth, in quotation marks, capital. The Commonwealth then claims that, quote, after directing a review of all physical evidence and data files, this video was located within a paper case file of the investigators, end quote. I believe that Mr. Brennan, when he came on the case, he's the one who directed a review of all physical evidence and data files. I would have to guess. Again, I would applaud that. Should have happened years ago.
Would you?
What's most curious about this video, however, is that the prosecution now admits, quote, after inquiry, it was learned that an investigator obtained this video from Canton Police Department in 2022, and it was placed in a physical case file, end quote.
What
That's a
case
direct quote
file?
from their opposition. They don't name who the investigator is. They don't
Oh.
indicate whose case file it was. They don't tell us
Oh.
where that case file had been, who had control over that case file, just a paper case file somewhere, mysteriously. Whether it was CPD or MSP, we don't know. Which investigator, we still don't know. What can we learn from this admission by the Commonwealth? That investigators did, in fact, download the Canton PD videos in 2022 before they were overwritten. That's the only way these videos could exist. We've talked about that. And what we don't know is where the rest of them went and why we don't have them and why we didn't have them for the first trial. The Commonwealth basically concedes that it is in direct violation of its discovery obligations not to have turned over these videos that were in their possession.
Sure
Makes the
do.
claim that it doesn't matter because, quote, the poor quality of the video makes it difficult for either party to benefit from the video, end quote. In its opposition, it sounds like more of a desperate argument than anything else that these egregious errors don't justify the court taking any action.
Cumulative, egregious actions, and the court isn't doing anything about it. Dear God, Alan Jackson, you have laid it all out, and no one can look the other way.
Because they claim, quote, there's no evidence of bad faith.
Mm.
I would take issue with that. But the quote goes on, there's no evidence of bad faith on behalf of the Commonwealth, nor any of its agents, particularly where the Commonwealth is equally aggrieved by the poor video quality and inability to obtain a forensically extracted copy of the surveillance video. Equally aggrieved.
Oh. Who the fuck does the Commonwealth think they are? Who does Hank Brennan think he is? You are not a defense attorney, sir. And as for Commonwealth v. Karen Reed, the Commonwealth is not yet on trial, sir. I guarantee I can't guarantee that because I am not an FBI agent, but I believe wholeheartedly that the Commonwealth absolutely will be on trial soon. And each one of you walking assholes will pay for what you have done and how you have impeded justice and the smear that you have not only done to the Reed family, but also the O'Keefe family, the children, and the citizens of the Commonwealth who have had to stand by and watch this shit show for over 2.5 years.
In that sentence, the Commonwealth admits that the defense is aggrieved. They say they're equally aggrieved, however. Aggrieved means wronged or unfairly treated or suffered harm or injustice. Merriam-Webster defines aggrieved as suffering from an infringement or a denial of legal rights. You bet we're aggrieved. But the Commonwealth can't claim that they're aggrieved when they're the ones doing the aggrieving. It doesn't work that way.
Oh.
The Commonwealth concedes that there's irreparable harm. They acknowledge that the forensic videos were destroyed, or at least they claim now that they're destroyed. We can never obtain the information necessary to establish the validity of any of these videos or whether and by whom they may have been manipulated, if at all. The Commonwealth can't shift the blame because the videos have literally been in their possession the entire time. It was their actions and the actions of their agents that caused this irremediable harm. Your Honor, this is, as I said, this is the definition of bad faith. And this goes back to the court's original question this morning, which is, can you describe the prejudice that Ms. Reed has suffered? And I think we've done a pretty good job of describing that throughout this argument. But the definition of bad faith means we don't have to prove actual prejudice. Prejudice is presumed under the law.
And it only goes for the defendants, right, guys? The Commonwealth has home field advantage. We see it every single court date. We have seen it since the beginning of our Commonwealth. And it has always been unbalanced, and that's why Lady Justice tries to equal the scales. That is always why we should be blind justice and trying to even the scales. This has been so tipped in the favor of the Commonwealth and has allowed these egregious misconduct and these just overstep of boundaries, habitual line steppers, the Commonwealth are. And Hank Brennan and his little fugly glasses and his dumbass voice cannot save you. Okay? He couldn't do it for Whitey. He can't do it for the Commonwealth.
If we're to believe the declarations that were submitted by ADA Lally and ADA McLaughlin and ADA Brennan, then at the very least, there is no other conclusion but that Michael Proctor and other investigators intentionally secured these videos. They withheld the evidence from us, and they withheld the evidence from the prosecution team. Let's take them at their word. Even after being explicitly instructed to turn over that evidence, that is bad faith. And how many times do they have to say, we didn't know about this? It just doesn't matter. Like I said, let's take them at their word. It doesn't absolve the Commonwealth of its obligations, and it doesn't reduce the prejudice that the defense has suffered. This was a pattern engaged in by the Massachusetts State Police, by the Canton Police Department, over and over and over again. And now we know through this new revelation that it was intentional.
Amen.
The prejudice the defense has suffered is legally presumed, and it's also factually proven. And thus the only remedy is dismissal. When is dismissal warranted? And this is, I'd like to talk for just a couple of seconds about the legal standards. Where there's misconduct that's so egregious, deliberate, and intentional, prejudice is to be presumed. That
Absolutely.
means the defense is not required to show Ms. Reed suffered any actual prejudice, because dismissal is necessary to prevent the repetition of this type of misconduct.
Woo!
That comes to us directly from Bridgman versus District Attorney for Suffolk District at 476 Mass 298. It's a 2017 case. Even if the court does not, and this is secondary to that, even if the court does not presume the prejudice and finds that these myriad violations were somehow inadvertent or a mistake, the result of some accident or negligence, this case still has to be dismissed under the second scenario and the second prong, because Ms. Reed has suffered actual prejudice by the Commonwealth's violations.
Yes.
We could not cross-examine these witnesses the way they should have been cross-examined at the first trial. The repeated and flagrant discovery violations were not an accident. I think we've established that at this point. They weren't a mistake. There were too many people looking at them, strategizing about them, to then say, I didn't realize their import.
And not only that, babes, not only the cross-examination, but the mere presentation of that video and lack thereof turning it over, the action, the lack of chain of custody, the brazen balls on Yuri Buchanan and also on Chip Proctor is mind-boggling. They were never going to look anywhere else than what sent them only looking for Karen Reed. I've said that since day one. They wanted no other evidence. They wanted to find nothing. And they would stop at nothing to ensure that they kept going down the path for the suspect that they wanted. We know that no taillight was ever found prior to Karen Reed's vehicle being secured back at Canton Police Department on January 29th, 2022. That is enough. And who didn't get to know that information? The jury, the fact finders. Their opinion would have changed had they known what we found out last Friday in a friggin' discovery dump.
They were designed specifically, the fact that we weren't provided the evidence was designed specifically to obtain a strategic advantage over the defense and to get a conviction at all costs rather than to pursue the truth. There are obviously additional Brady violations and prejudices that Ms. Reed has suffered. I've detailed those in our moving papers. And I want to incorporate all of those arguments by reference here as well. But relating to the surveillance footage itself, there's no question that the Commonwealth intentionally withheld it, and they've been withholding it since January 29th, 2022. The Commonwealth can't really seriously claim, Your Honor, that 4 or 5 or however many different law enforcement officers were aware of and withheld the surveillance video or the surveillance footage, and who were supposedly specifically instructed by Adam Lally or his team back in April of 2024 to turn everything over, and it was just inadvertently withheld. This was intentional. And the Commonwealth then compounded those violations by Michael Proctor lying on the stand about his knowledge of the video footage and his turning it over to the defense. It was literally a fraud on the jury.
Ooh, ooh.
And now, well after trial, the Commonwealth has been forced to admit that even more exculpatory evidence or surveillance evidence from January 2022 is in their possession. And it was also entirely withheld from the defense throughout this litigation and throughout the first trial.
Jesus, take the
In
wheel.
addition to the presumptive prejudice, Your Honor, there has been actual prejudice. This was, some would say, a close case when it ended. The court recalls.
Babe, KCL says, I can't imagine how Karen must feel. Look at her face, babe. Look at her. She's exhausted. I talked about this morning, right? The whole team, the whole family Everyone is exhausted. The O'Keefes are exhausted. And can you imagine that this dick right behind me has done what he has done to everyone, to the families, to residents. And I truly fear that if you looked deeper into Trooper Michael Proctor's conduct over the last 12 years of his employment, that we would find a slippery slope, because this didn't happen overnight. Karen was not his first egregious misconduct. This is something that chips away at you, that chipped away at Chip Proctor. And over time, he was able to spin his web of lies and take it to this length.
That the jury was hung on some charge or charges, and the evidence suggests that they voted in her favor on others. The court needs to ask itself, what would the jury have done had they had all the evidence to which they were entitled, to which we were entitled? But they didn't. Every one of these videos was in some way compromised, even the videos that we did have. And the compromise always conveniently obscured the truth and obscured Ms. Reed's rights. This is an exculpatory fact that we should have been able to explore during the past 3 years, and certainly we should have been able to explore it at trial, but we did not have the videos. The Commonwealth did, though. And it's the cumulative effect of all these gross and repeated violations that undermines the Commonwealth's argument that this is just about a broken camera. It couldn't be further from the truth. We're to believe that all these cameras just spontaneously became defective at the exact same time. Like I said before, it defies logic. For the Commonwealth to have all this footage for a solid 3 years and hold it back from us the entire time, it makes one question what was going on with that evidence.
Yes.
Now, I have to say, in terms of lesser remedies, Your Honor, what's interesting is that the exclusion, obviously the exclusionary rule exists.
I understand that does not help the defense.
It doesn't help the defense. And I appreciate the court finishing my thought on
That was huge, guys. Now, think back in time. Turn back the hands of time. We have never heard Judge Cannoni say when Alan Jackson is presenting anything that she understands that would not help or assist the defense. A lesser remedy, changing anything, would not help the defense in this case. Bitch, I clenched so hard, I could barely breathe. Is Judge Cannoni seeing the light? Will she at least have an evidentiary hearing? I believe she will.
that. It's the opposite. The only remedy that can prevent this kind of repetition, this kind of misconduct, is dismissal. That's the only remedy available. And that's what the law, and that's what justice demands. As a final thought, if the court, even in the face of all this overwhelming evidence of gross misconduct, declines to dismiss this case at this time, we would urge the court to grant us an evidentiary hearing so that we can make an actual factual record of the myriad of issues brought up here. This will give the court a much better understanding of the facts supporting dismissal, and it'll perfect the record on these critical constitutional issues. And with that, I'll submit.
Okay, so thank you. I have a question for you. So go back to the podium, please, because you may need your notes. But Ms. Little, did you find the Proctor testimony?
I did, Your Honor. It's June 12th, 2025, the reporter's transcript at 1-148. And that's from the copy of transcripts with sidebars, just for the court's reference, lines 8 through 12.
Great.
Thank you.
She meant
I have
24.
a question, Mr. Jackson, just about, so you argued obviously the importance of the Lexus arriving at the Canton Police Department. You argued a distinction between a cracked taillight versus a shattered taillight.
Correct.
In your pleadings, and again, you just saw, I want specifics where I can find something. On page 28, you talked at the top line, cracked, not shattered, when it arrived at the conflicted CPD on January 29, 2022. If the taillight was largely intact and only cracked, rather than shattered and missing 47 pieces, as Dighton Police Officer Sergeant Barrows testified he observed earlier that day, after the Commonwealth claimed Ms. Reed had struck Mr. O'Keefe, the evidence would establish Ms. Reed's innocence and be case ending for the Commonwealth. The 47 pieces I'm having trouble finding.
Oh, I'm sorry, Bev. Were you here Hi, babe. I know you're still in your winter blonde, but were you present during trial 1? Because all I recall is hearing about those 47 pieces of taillight. Sometimes I thought it was 45. But after seeing the incomparable Mix Valaire get up and show the puzzle pieces that they put together, and that we conveniently found out that specific pieces were found by who? Right behind me. Good old Bukak. Also, Kenny Berkowitz. Everybody found their own pieces of taillight in specific quadrants. And it was 47 pieces of taillight found over 3 weeks. Most of the time, just by officers who were off duty. One was out on a medical leave of absence. Drove by and just kept finding taillight. It kept revealing itself. Quite magical. Unbelievable, actually.
Just took a quick review of Sergeant Barrows's testimony yesterday upon being prepared for this. I didn't see it in there. Ms. Little, do you know where that 47 pieces is?
Yeah, the 47 pieces is not related to Sergeant Barrows' testimony.
Well, it sounds it from this, so I'm not to
No,
read it this way.
No.
What Sergeant Barrows clearly testified to was that he observed a taillight that was cracked and not broken.
Okay, the 47 pieces, I read that to mean it was from Barrows's testimony.
No,
It was
there-
as Dayton Police Barrows testified. All right, where do I find that 47 pieces?
So 47 pieces, I can get multiple transcript sites, but those were the photographs the Commonwealth presented at trial.
I don't know. I don't know, Bev. I don't know where you'd find those 47 pieces of taillight. You'd have to ask the fucking Easter Bunny. Okay? Maybe call the Tooth Fairy. Because it's not real. Call Kevin from the Yellow Cottage. I don't know. He likes fiction novels.
That there were that many pieces found at the crime scene.
The number of
Taillight.
pieces that were booked into evidence.
Okay.
Yeah.
Great. Yeah, if you have trial transcript of that, I don't need 47 points, but if there's something that summarizes it, put that to read as I see it reading.
No, Sergeant Barrows specifically testified about his observations of the taillight earlier that day.
Right.
It was uncontroverted that there were 47 pieces of taillight
Correct.
recovered at the
That's not clear to me the way this is written, so I'm glad I asked you. Okay. All right, so with that, now, Ms. Tinetti, I'm not going to hear from you now about the court officers not being in charge of the jury. I'm going to hear from Mr. Brennan, and then we'll get to you, and hopefully we'll have time. But Mr. Brennan, I have a question for you. As I started with a question for the defense. So I'd like you to explain to the court, please, what efforts the Commonwealth made to comply with the Rule 14 obligation regarding the Sally Port videos, and why the dribs and drabs of the way the discovery came in.
Well, I just love that legalese, right? It's really awesome to hear Judge Polly Pocket up on that bench, all 5'0" of her, asking about dribs and drabs of discovery. Oh, if this was the defense, she would have had grave concerns.
It may be most helpful if I give the court a history as I've learned it about the production of video in this case.
Okay.
And it will explain in context the production of video and will help create the foundation so the court can understand, and perhaps the defense can best understand.
All right, and just like I did with Mr. Jackson, if I need to, I'm going to interrupt you
Of course.
to clarify some of this. So no,
I just wanted to say, babes, as soon as I heard him speak, okay, your girl made an observation. And what was it? I was there yesterday, and yesterday we got a little bit of what? We got Hank with a full tank. Okay. He was ready to rock and roll. He had little quips. He was making the eyes at his little paralegal in her ill-fitting, pencil skirt. And those two were connected. He's rolling his eyes like a 15-year-old broad. And he was absolutely snarky as all hell. This tone, even for a weaselly little rat like him, seemed more contrite, in my opinion, coming out of the gate.
that's what I'm focused on.
I understand clearly. In November of 2024, the defense asked me to see if I could provide a chain of custody regarding the production of video in this case. And so I agreed that I would do that and made best efforts to talk to as many witnesses as I could, review the discovery, and speak to the attorneys. Now, when
Oh, I'm sorry. Would you like a medal, sir, or a chest to fucking pin it on? That would be your job.
I started sometime in late September, I had found the letter from Chief Rafferty with the production of video in August. The letter or note was dated in August. So to start from the beginning, the prosecutors in this case did not have knowledge that there was videos from the Sallyport area. There was nothing about it that was particularly relevant to them. The defense theory did not make it clear to them that that was important. There was no motion filed by the defense.
At what point in time?
This is leading up to trial. At
Okay.
that point, there had been no request by the defense for video of the Sallyport area.
Okay, I'm going to need to stop you right there. Hank, shut the fuck up. Shut all the way the fuck up. Shut the fuck up, Mountain. Okay? Stop it. You're not dumb. And what do you mean they didn't ask for it? David Yannetti, at arraignment of Karen Reed for her manslaughter charge on February 2nd, 2022, requested in writing for a signed order to maintain all physical evidence. And you don't think that the video of where her vehicle was towed at the request of lead investigator, Trooper Michael Proctor, to go specifically to that location shouldn't have been maintained by the Mass State Police and Canton Police Department? Stop it.
What I learned is that Trooper Proctor had requested Sallyport video from the Canton Police Department. And the person who was the custodian of Canton Police Video, who would download it from the DVR, was Sergeant D. Giampetro. He made a request shortly after this event on January 29th, 2022. Sergeant D. Giampetro downloaded video from the front wall camera, which was later characterized as the blurry camera, and he left it at the front desk. Trooper Buchanan, at the direction of Trooper Proctor, picked up the video and he brought it to Trooper Proctor. Trooper Buchanan did not look at the video at that time. It was given to Trooper Proctor. Trooper Proctor did not provide it to the prosecutors. So Trooper Proctor was aware of the video. The prosecutors were not aware of the video. That video is the same video that Sergeant D. Giampetro says that he downloaded the video in 6-hour segments, and that contained the front wall, blurry camera inside the Sallyport, and camera in front of the police station. That remained with Trooper Proctor for some time. In June.
Oh, and where is Bev? Where's the dates? Where's anything requested here? Are you shitting me? So now you're saying, I do like to see it though. I'll tell you that much, babes. This is the first time we're seeing like the pig pile on Proctor, right? Everybody is playing hot potato like a mofo. Nope, not on me, not mine. Right? But the question still leads. As you look at that little squirrely rat hybrid in front of you, Hank Brennan, he's saying that yes, Trooper Proctor requested all of this video footage. D. Pietro. Apparently, all of us can't say it. I apologize, sir. And he gets this information because he knew damn right well that he needed to make sure that stuff wasn't seen. That the condition of that taillight was never seen. Do you hear me? That's why he asked for it. And then now Lally and McLaughlin, no one else knew. It's all fallen on Chip. Well, guess what, babes? Chip is an extension of you. Boo boo. So what he does, all of you need to be held responsible for. Right, Bev?
Around June of 2023, Trooper Proctor then made a second request from Sergeant D. Gianpietro
Even though we already had it?
for different cameras. He wanted cameras, camera angle of outside the Sallyport area. So when the tow truck dropped the car off, leading into the Sallyport, which is now characterized as the exterior Sallyport video. Again, Trooper Proctor asked Trooper Buchanan to go to the Canton Police Department and pick up a copy of the downloaded video. Trooper Buchanan went to the police department, picked up the CD at the front desk. That CD had a yellow sticky tab on it with Trooper Buchanan's name, and Trooper Buchanan wrote in the case file on that yellow sticky. He brought the CD to Trooper Proctor. Again, Trooper Proctor in June 2023.
I fear that Blue from Blue's Clues and fucking Steve would have done a better job at labeling evidence in a unaliving trial than these assholes.
We had a copy of the exterior Sallyport video, but did not provide it to the prosecutors. Both of those videos remained dormant. When Trooper Proctor was called to the federal grand jury.
Oh, Bubba. Okay. I'd like you to break out the Merriam-Webster's dictionary. Dormant, like Mount St. Helen. What are we talking about? It wasn't dormant. Your homeboy had it, and he did not provide it. So what's that, Bub? That's called actually withholding exculpatory evidence.
Essentially, he testified or was asked about video and said that he reviewed video. Now, this was not evidence that the Commonwealth intended on introducing or had any specific interest in. There was no particular discovery request by the defense, and there was no order. But upon reading that grand jury testimony, ADA Lally reports that he then inquired about the video. This is
Inquired of whom?
Trooper Proctor. This
Oh,
is shortly before trial. ADA Lally.
We named
was given
him.
A copy of one of two of those productions. He was given the copy of the front wall video, which also contained video of outside the front of the police station. That was quickly turned over after Attorney Lally received it on April 4th, 2022. So what we know at this point is
April
Trooper Proctor
4th.
has this original production on April 4th, 2022, shortly
no.
after January 29, 2022. I'm sorry. It was provided April 4th, 2022.
I don't mean to do this to you, but I feel like saying stuttering Stanley. What are we doing, Hank? Nothing was provided in April of 2022, and you just said it 5 times. Let's get it together. It came out during trial. That would have been April 2024, apparently.
2022 or later?
No,
It was later,
It
right?
was
Because
later.
the
It was-
federal grand jury was later.
he provided it on the eve of trial. So it was April of 2024. So we know this production on April 4th, 2024 was in the
No worries, babe. Just 2 years later. Cool.
hands of Trooper Proctor in shortly after January 29th, 2022. At this point, the prosecution team is still unaware of the June 23 production, which has Trooper Buchanan's name on it, which shows the exterior Sallyport. As trial began, there still was no specific order or request. The chief of police saw something about the trial in, let me rephrase, prior to the trial, it's reported that Attorney Yannetti was discontent because the video of the front camera Sallyport was so rainy, intermittent, and not continuous. And that's an accurate description of that video. Chief Rafferty, in response to seeing Attorney Yannetti's concerns.
I'd like you to point me to the transcript of Yannetti saying that, because I don't believe it.
Then asked Sergeant D. Gianpietro to see if there was another camera or to produce any other video from the Sallyport. Sergeant D. Gianpietro then downloaded video from the DVR, which is the second camera that is inside the Sallyport, known as the inverted camera, or now characterized as the inverted camera.
Downloaded.
That was produced April 23rd, 2024, given to ADA Lally, then given to the defense. And so at that point, there are 3 video productions that exist. The first turned over to the defense April 4th, 2024. The second.
3 video productions that have been given to the defense. We heard that, right? Where the frig are the 6-hour chunks? Because all we've gotten, to be perfectly clear, is the entry into the Sally Port with 46 minutes, I believe, of missing footage. Where are the other hours? Hours. Vast majority. We're missing, I don't know, over 22 hours? Where is it, Hank?
April 23rd, 2024, and the June 23 production of the exterior Sally Port has still not been turned over. It's in the possession of Trooper Proctor, and the prosecutors do not know about it. After the trial, one of the employees from Norfolk County, Colleen Crawford, went to the Sally Port and looked at the DVR system.
When after the trial? Because we know Colleen Crawford was retained after Hank got in as the new special prosecutor. We remember this. I remember it like it was yesterday. So it had to be after September when he came on the case. And then this shocked me.
And when she looked at it, she saw that video still existed on that system.
Oh, everybody, take a moment. Take an actual moment. Let's do deep breaths. Let's find a goat and do some fucking goat yoga immediately. Colleen Crawford in 2024, sometime after fucking September, went to Canton Police Department as the forensic guru. Digital forensic fuckface. And she finds that there is still video from January 29th, 2022 that existed on that system. Well, now, smack my ass and call me Susie. Because everything that the Commonwealth has ever told you about this Sally Port video, Canton Police Department, the 30-day loop, the big lie has been revealed. And Hank Brennan himself has revealed it.
Although there was a 30-day overwrite on that system, the system had a number of backup hard drives. And because
Okay, so because they still had an override, the backup hard drives kept the video footage on it. But yet the defense's expert coordinated with that very same Colleen Crawford to come up in December of 2024. And sometime between September and December, the backup drives and whatever was wiped. Would that not be the definition of tampering, friends? Because I think it is.
of the backup hard drives, the video existed longer than 30 days. She wrote an extensive report that was turned over to the defense, and this is after trial. The report notes her investigation about all the different videos, and it summarizes everything that she saw in that July 2024 visit. As I mentioned earlier, in August, Chief Rafferty provided video of the hallways that included some video of Brian Higgins, and she accompanied a letter or a note. I learned that that video was copied during the trial, and it is noted in the sergeant's letter. The chief of police and the sergeant were downloading video, not in response to a motion to compel or produce, but rather because they had concerns about accusations that were being made about the department and they were saving video, in their opinion or from their perspective, to help defend against future false claims against them. They downloaded a number.
Future false claims against them. Babes, if this doesn't sound like a guilty conscience to you, I don't know what does. I don't think many police departments proactively are, fighting back and producing snippets curated by themselves to get ahead of a story. Sounds more like a PR move.
Videos that were then turned over in that August 2024 production. When I first learned of that August letter and note, I turned it over to the defense immediately. The issue came up regarding the DVR in November, and as we've litigated extensively, so I'll simply summarize it. I invited the defense to come to the Canton Police Department. Given the intermittent or spotty production of video, I thought it best they have an opportunity to look firsthand, although I didn't know if the video would exist, as I said.
So why wouldn't it though, Hank? Here's my question, you goddamn son of a bitch bastard. You got up in front of all of us, in front of the court, and made another misrepresentation of fact. If Colleen Crawford had just gone up and produced video from January 29th, 2022, why in the fuck wouldn't it have been there when the defense expert went? You are a liar, and I have never prayed for someone's actual pants to catch on fire more than I did during you speaking right now. You deserve a fungal toenail infection that is permanent. Okay? No fungi nail should help you. You prick.
And then when they came in December, I think it was December 12th, if my memory serves, and learned that there was no longer video stored because it had been overwritten, I then went to the Canton Police Department so that I could have a closer look at the video cameras to see if there was something missing. I toured the entire station. I learned.
Quick question, Hank. Since when, right? I thought that Colleen was hired to become your digital forensic guru, right? But you decided afterwards that you needed to go up and to take a tour of the entire police department, and you were just putting on your little investigator hat, okay? Your Doc McStuffins up there, okay? Columbo, if you will. All right? And you wanted to see what was really happening. Spare me.
Learn about the videos, and then as a consequence, I spoke to the chief, other officers, and the sergeant unexpectedly. The sergeant told me that he would click and drag copies of video when he would
Click and
download
drag
them from the DVR. Inevitably,
I would like that to be his drag queen name. Click and drag.
we had the litigation about whether the defense was going to download in person or not. And then as I tried to finalize my investigation into the tapes and realizing there was no actual written chain of custody, I wanted best to memorialize it. I had been reviewing all files, data, hard files, but I had not been on the case long enough to review.
Hold that thought, babes. I'm so sorry that I apologize for this, but hold that thought. After discovering that there was no chain of custody, I wanted to make one up. I wanted to memorialize it. And based on that sentence alone, Judge Beverly Cannoni should be obligated by this transcript to at the very least, have that evidentiary hearing requested. That is the key. And Karen will be free.
View everything. So I asked that the parties of the Commonwealth look through all files, all databases, so that I could help facilitate my review. At that point, I was provided by Trooper Tully the June 2023 CD with Trooper Kennick's name on it. That is the exterior Sallyport video. And within 24 hours, I provided that to the defense. I then asked both the sergeant and Trooper Tully and Trooper Mechanic to write reports. Since there was no chain of custody, I wanted best to give as much information as I could and document the history of the video. That, Your Honor, is a summary of everything that I learned, the investigation, and the production of the videos.
And here's how the Commonwealth fucked up yet again. There it is, Judge Canoni. How'd you like that? Did that tickle your fancy? Polly Pocket, you like that one? I think you did.
Do you know which investigator's file it was found in?
Trooper
Oh.
Proctor's.
Trooper Proctor. And who is Trooper Proctor's file for? The Karen Reed case. So who had access to that file at all times? Adam Lally, Laura McLaughlin, and shithead Brennan upon his retention. Hope you like that $225K, Hank, because I don't know if you're going to be getting a lot of work as a defense attorney after this one.
Okay.
Your Honor, I have 3 separate arguments. I will proceed with the videotape argument since we've lodged into it.
Sure.
Now, the defense has made a number of conclusions that there was somehow videotape that was tampered with. There's absolutely no evidence whatsoever, none. It's not even speculation. There's no evidence that any videotape was ever tampered with. They say it, but there's none. I have seen none.
Right. Right, Hank, I'm just going to bring you back to the statement and the sentence that you just said right before this, that you acknowledged that there was no chain of custody. And you acknowledged that after trial, there was still video footage from January 29th, 2022 on backup hard drives. And then magically, mysteriously, and, by the power invested in, I don't know, potentially the boogeyman. It was removed. It was there, and then it wasn't. It's the ghost of Whitey Bulger went to Canton Police Department and erased that bad file. But you've never seen tampering, but you've described tampering to a T. I love playing this game with you, Hank. You're an absolute fucktard.
They have produced absolutely no evidence that any video was altered or tampered. The defense lodges the idea of bad faith, that there was some type of advantage in that this video was withheld from them on purpose. And again, that is a baseless claim. If the government was going to hide video from the defense, they never would have got it. Maybe they would have got something after I came in and looked. They would have not got this production in April 2024. They would not have gotten the production if the government was looking to hide anything. And so the idea of intentionally withholding or bad faith is just a characterization by the defense. The words Brady have meaning. Now, first, Brady needs to be exculpatory, and that's going to be something I think I can demonstrate does not fit this case. And secondly, in order to compel the court to conclude there was some type of remedy that should be issued, they want the court to conclude, like they do, that there was some type of tampering or some type of destruction of evidence. There was none. There was none. Now, Trooper Proctor,
You have described it.
this video from June 2023 in his file. And I think the best evidence that this was not intentional is if you review Trooper Proctor's trial testimony.
So do you have a volume? Is it at the same place that Ms. Little gave me?
Well, I have the same volume. They gave you a fragment of his testimony, which is about 3 sentences. But if you actually read a number of pages, testimony that deals with this video, and it begins on page 133, what you will see, and I won't spend a half hour reading it, but what you will see
Please,
is
Christ.
that Trooper Proctor was aware of the grainy video, which was the video that was provided right after January 29, 2022. He was unaware of the inverted video until it was produced right before trial or right during trial by the Canton Police.
See, now, and this is when we know that Hank is absolutely just lost in his own sauce, okay? When he's saying he was unaware of the video that was produced at trial or the inverted video, all of the video that was ever produced in Commonwealth v. Karen Reed was produced to give to Trooper Proctor. All of it. All of it. I need you all to actually take that in. DG and Pietro produced all video from Canton Police Department and turned it over to Proctor. So this argument you're making, Hank, makes you look dumber than you have for the last 30 minutes.
Police. And you can also see that he in no way was hiding the June 2023 video.
Yeah.
Because you can see the confusion between all the parties at trial. Attorney Jackson is asking.
He put it in the dormant Mount St. Helens file, don't you know? He wasn't hiding it. It was just in a paper file, and it was dormant. And it was never shown to Lally or McLaughlin, allegedly. Hiding it? Never.
Trooper Proctor about video, and Trooper Proctor is explaining there is a Sallyport video, and also there's an exterior video outside the Sallyport. And it is clear that Attorney Jackson does not have that June 23 exterior Sallyport video because he's very confused in the questioning of Trooper Proctor. And Trooper Proctor continually tries to explain that there is both the Sallyport and there's the exterior video. So clearly, Trooper Proctor was aware of the exterior Sallyport video, but it will be clear from the reading of his cross-examination that there was no intentional withholding. He should have, since it was in his possession, whether it was relevant to the government's case or not, he should have provided it to the prosecutor, and then it would have been properly provided. But it was his oversight. There was nothing intentional or advantageous about it because he struggled to try to explain to Attorney Jackson. And so it's also notable that Attorney Lally never has an opportunity to ask more details about those. Well, he has the opportunity, but he doesn't ask more details about.
Oh, did you see that one? Did you see that little quick quip that Hank comes in hot with? He says, well, Adam Lally had the opportunity, but he never asked the questions. And Adam Lally's negligence is not Karen Reed's problem. Okay? And she shouldn't have to pay with her life being on the line when the prosecution didn't do their job and the investigation was a sham from day one. Rest in peace, Officer John O'Keefe. I'm so sorry that Mass State Police, Canton Police Department, and the Commonwealth of Massachusetts have let you down and your family down after your service as a Boston police officer for 16 years.
That misunderstanding because he's wholly unaware that it even exists. It's a confusing moment, but it clarifies that there's nothing intentional whatsoever about this course. And so it's important that although the defense now suggests there's something exculpatory about it or something about it that's important, it is important to note that the defense never filed a motion for the production of the Canton Police Department video. It's not
Wrong.
incumbent or assumed that the Commonwealth is going to obtain every video from every part of a town during an incident. It's not assumed that they will do that. The Commonwealth seeks evidence that they think is exculpatory. They seek evidence that they think is relevant material, and when they receive it, they are supposed to provide it. There are many cases where video from a police department is never provided to the defendant unless they ask. Or many cases where it may be a video of the booking, but not the hallways, not the bathrooms, not the back parking lot.
Quick question. Is there bathroom footage that we haven't seen, babes? Huh? Because I know that we got a hallway, and I know that we have the front and the Sally port. But that's interesting that he said bathrooms.
Put in context that the defense theory was a evolving theory throughout this case to this day. The defense theory
No.
was that it was some third-party culprit, unidentified, who committed this act that led to the death of John O'Keefe.
But you know what hasn't ever changed, okay, Hank? And again, this shows your lack of summer reading. We have always been convinced, and we have said, even as supporters, had there been one piece of red polycarbonate plastic taillight found at the scene at 34 Fairview before Karen Reed's vehicle was transported via tow over 30 miles in a blizzard back to Canton Police Department, when there were several other barracks and Mass State Police areas in which that vehicle could have been sent, but it was chosen by Michael Proctor to go to Canton. And I don't care if it was 10 minutes, 5 minutes, 7 minutes of a window. Karen Reed's vehicle was dropped off and delivered, and in that Sally Port prior to the first piece of taillight being found. In the dark, after another 12 to 16 inches of snow had fallen, versus the AM with a leaf blower that Lieutenant Gallagher showed us all, and he found clear pieces of drinking glass around the final resting place of Officer John O'Keefe. But in the daylight with a leaf blower, you didn't find one piece of polycarbonate plastic. It's because it wasn't there, Hank. And you know that.
In fact, if you see earlier interviews, the defense position publicly was, you know exactly who did it, intimating that there was a specific person. Now, that recently has changed. If you see the recent interview 2 weeks ago on Fox 25,
Talking
the quick
shit.
answer was, we have no idea who did it. We don't have to know. And so this fluid position is not noticed to put the Commonwealth on notice. They're supposed to chase down every potential idea or creation that the defense has. It's important to look at the motion that has been presented to your honor on behalf of the defense, where they claim that they moved to preserve video evidence. And when you look at that motion, the best it says is that they moved to compel physical evidence. That does not put the Commonwealth on notice of video evidence at the Canton Police Department.
Was this the Stoughton District Court motion?
It is.
Okay.
And I know the Superior Court did not adopt it. However, I think the Commonwealth being on notice is the point. Even if it's in district court, I think it's the Commonwealth's responsibility.
I agree with that.
Okay. And so Attorney Yannetti, and I've mentioned this before, was very prolific in his pretrial discovery motions, very meticulous. And when you look at his meticulousness, if there was a need or a desire for video, he certainly would have asked for it. He didn't. In fact, when you look at the perspective of Attorney Yannetti, you don't have to look much further than his characterizations of how he sees the difference between the crime scene and the Canton Police Department. I've attached, for your honor and for the defense, exhibit number 4, trial testimony of Trooper Nicholas Garino. And when he cross-examines Nicholas Garino, he is pretty clear that there is a difference between the Canton Police Department and the crime scene. He cites on page 75, but you'd agree with me, the Canton Police Department wasn't the crime scene, correct? And Trooper Garino says, I never said crime scene in my report, I wrote scene. And Mr. Attorney Yannetti iterates, okay, well, Canton Police Department was not the scene of any crime, was it?
So you think that David Yannetti, our David Yannetti, asking Trooper Guarino if Canton Police Department was the scene of a crime is somehow exculpatory for the Commonwealth? Oh, Hank, do you know how to do this? Honey, that's not a good look.
So the defense is hard pressed now at this moment where they are trying to create prejudice that doesn't exist, to try to convert a motion that they filed with very specific intentions for physical evidence to now suggest that that includes Canton Police Department because the Canton Police Department is somehow the crime scene. It doesn't convert. In argument, Attorney Jackson characterizes not only Trooper Proctor's testimony, and I encourage the court to look at that because when you read it in context, I think it clearly screams that Trooper Proctor is hiding nothing whatsoever. But if you look at Trooper Buchanan's testimony, on June 6, 2024, if you start at page 103, Attorney Jackson, to paraphrase, I'm not quoting him verbatim, suggests that there's something about Trooper Buchanan that is lying about his position or about what he saw.
Yeah.
Trooper Buchanan admittedly saw the inverted video. Not the case. Trooper Buchanan reported that he did not see the inverted video until after Canton produced it, because how would he see it before Canton produced it? And that was in his preparation in May. And he did not say that he sat down with.
Oh, the dumb fuckery continues. I apologize, babes. When Trooper Buchanan said that he saw the inverted video, it's because for a day and a half, he talked about the inverted video with Adam Lally in direct testimony. And he said, yes, this is a accurate and this is an accurate representation of the Sally Port. Yes, it is. Absolutely. Yep. 100%. And then the first question on cross was, hey, babe, you know that that's not actually an accurate representation. That's the exact opposite. And he says, yeah, I know that. So again, you look kind of dumb, Hank.
ADA Lally and watch the inverted video. He was asked, were you shown any of the videos that you've seen in anticipation of your testimony? Now remember, there's not just Canton Police Department video at that point. There is video from Ring, Town Hall, a number of different places. And he said, not during the first meeting. I did review video during the second time. Question, okay. And that video that you did see the second time, was that the interior video of the Sally Port that we saw yesterday, correct? He says, Trooper Buchanan, I'm just trying to remember exactly what video I saw. I have reviewed videos outside of our meetings. That is what he put in his report about reviewing in May, not with ADA Lally. So I don't remember exactly what video Mr. Lally showed me. That wasn't the characterization that was provided in argument. This is very different. Question, but you do recall seeing the video that you saw yesterday, the sort of clear one that has the crime scene tape being put up and all that. You've seen that one before. That's the inverted video. The answer, yes, I'm on page 104. And that was with Mr. Lally, correct? Trooper Buchanan, clearly. That is not correct because I do not recall when I saw that video or what video I saw with Mr. Lally. That sworn testimony is not only in stark contrast with the characterization that was offered by the defense, but it directly contradicts the conclusion they asked you to reach, that Trooper Buchanan watched this video with ADA Lally in preparation for trial. Therefore, it is a lie that the Canton Police Department provided the inverted video sometime earlier. That's sworn testimony. Now,
He said it in his report.
again, trying to assert some type of relevance, the defense suggests there is something in the federal materials that would show relevance because Mr. Higgins said in federal materials that he does not believe he made any phone calls. If you were to look at that testimony in the federal materials, you would see there was an enormous amount of conversation about the period in which he was sleeping. And there were dialed calls between him and Mr. Albert. And so you have to look at it in context rather than say it's an unequivocal denial and there's an aha moment. There is no aha moment. So
Do you have the grand jury cite? I think I might have got it from Ms. Little earlier, but the grand jury testimony of Brian Higgins, I have it. It's just easier if you have a cite to that.
I have a tab, but I don't perhaps turn.
I'm sure Ms. McLaughlin can get it.
I'll provide it momentarily.
All right, thank you.
So what really arises from the subterfuge is that the defense did not ask for video. There was video provided when the prosecutors learned about it. There was video that was in the hands of Trooper Proctor that should have been provided to the prosecutor that wasn't. There was nothing done to alter or taint the video. There was nothing destructive about it. There was no tactical advantage. There was no benefit to the government. And clearly from Trooper Proctor's testimony, there was no effort whatsoever to hide it. It should have been managed better, no doubt. But there was nothing about it that was prejudicial. There was nothing about it that showed tampering or altering. And so ultimately, the import of the defense's argument is that this evidence, this information is exculpatory. It's exculpatory because what they claim is that it would show that Ms. Reed's taillight was cracked, not missing a piece. Now, first thing we look at is Nick Barros' testimony. And if you have an opportunity to look at his testimony on page 12, line 1, the defendant told you part of the story. I saw some damage to the rear taillight. To my best ability and recollection, that taillight was not completely damaged. It was cracked, but they forgot the next part. And there was a piece missing, but not completely damaged. That's exactly how we see Ms. Reed's car later on after it is at Canton. The entire taillight is not missing. There is a piece missing.
45 to 47 pieces of taillight are missing. It is an entire compartment. Yes, it is not the entire housing, but it's an entire compartment, a huge area that you allege struck Officer John O'Keefe's arm and spontaneously combusted into that 45 to 47 pieces of taillight without bruising or breaking his arm.
That piece, where the fractures of it are found at 34 Fairview, right near Mr. O'Keefe's body. The same parts of the taillight fragments that are found in the sleeve of his shirt. And so,
Shut up. Shut the fuck up. Also, quick question. That is kind of weird. And I've said that since day one, Hank. You're absolutely right. All 40 something of them were found right in the yard of 34 Fairview. Although a couple hours later, the road was plowed multiple times by who? Lucky Lawfren. So if this crime that you allege from the Commonwealth occurred at approximately 12:32 a.m. on January 29th, 2022, at the 2:30 a.m. pass by Lucky Lawfren, those pieces of taillight that had shattered would have been moved by said plow, and that would have moved the pieces up into, as Matthew McCabe calls them, the maybe up near the Asian family's home, or even further up the road. But every single piece was found right there during a massive weather event. Maybe you should ask your fucking meteorologist if that makes sense. Because Karen Reed was never alleged to have driven up onto the grass and strike Officer John O'Keefe. She drove as like a bat out of hell, like Mario Andretti's wife, reaching a speed of 24.2 miles per hour in reverse, straight for 62 feet, struck her target of Officer John O'Keefe in his arm. And it resulted in his death. And every piece was found in that yard. We were born at night, Hank, but not last night.
so it's not simply cracked. Even the witness they tried to lean on, Mr. Barros, says more. And so if that taillight is not just cracked, that taillight is missing, then there is nothing exculpatory whatsoever about the Canton video. It's a red herring, because there can be no plant of fractured taillight if it's already gone before it gets to Canton. There can't be. And so when looking at the evidence, it is unequivocally clear that piece of the taillight is missing well before that car ever gets to Canton. And so we can quibble and we can dispute.
Suspicious, don't be suspicious.
John Ralphio? John!
In fact, the claim that the Sallyport videos were tampered with. Canton went back before January 29, 2022, and they took samples of the video to see if it was in the same condition, inverted for the back wall and fuzzy for the front wall. And we have those, and we turn those over to the defense. And I just wanted Your Honor to see a small clip of that to show this condition, these conditions existed before this case was even a moment. So with the court's permission, I'm going to ask to put up exhibit number 2. Exhibit number 2 shows the inverted camera from January 1st, 2022. Now this is 28 days before Ms. Reed's Lexus hits the Sallyport area. Now you can see, if you stop that, please. Thank you very much. On that wall, on that garage wall, there's a 4. It is backwards. This Sallyport video was not doctored by Trooper Proctor. It wasn't altered by Trooper Buchanan.
Doctored.
It was in existence well before Miss Reed's car showed up to that Sallyport. Similarly, front wall camera.
Wasn't it always blue, the writing?
Exhibit 3 is from January 28, 2022, a day before Miss Reed's vehicle makes it to the Sallyport.
Maybe I'm wrong.
It wasn't distorted on purpose. It wasn't manipulation by the state police. This is the way the camera worked in Canton.
Oh.
Thank you very much. So the idea of tampering, we can claim it, we can assert it without fact, but we can prove it did not happen. Now, what we know is that missing taillight was not tampered with because it was gone hours before police even touched Miss Reed's vehicle. At 5:08 a.m., she left Meadows Road. That's John O'Keefe's home. And when she left at 5:08 a.m., that taillight part was already missing. If we look at Exhibit 6, please. And this is from the ring video of John O'Keefe's home. This evidence directly contradicts the idea that the Salvatore video is.
Great question, Danny Thomas. How did they get video from Canton Police Department Sallyport of January 1st, 2022? What about the 30-day loop and the overwriting? Like, how would you have had that as your, I don't know, your proof or your evidence that there was no wrongdoing by the Commonwealth from a date that predates the 3-year mark that we've already passed? In this case, is that like sample footage? What the fuck are we doing?
Relevant to show any break or planning of evidence. As Ms. Reed nudges into Mr. O'Keefe's car, she will pull forward and we'll stop the video in 2 spots so you can get a clear look of that rear taillight missing. Forward, please. Thank you. And then ahead one more. You can see the white light shine. Stop. You can see it clearly missing. You can't plant something that's already gone.
Oh.
And the reason why you see white, it is a red taillight cover, and when the red is missing or gone, as it is in this case, the white bulb still shines, and that's why it shines white.
Oh my God. Okay, I think I fast forwarded through this, guys. This is wild. I'm sure that 9,645 people have corrected this, but that doesn't match up to what part of Karen's taillight was gone. Oh, and why does it look like it's white on the other side? Oh, Hank. Hank, this was a poor choice.
The defense position is also contradicted by the ARCA witnesses. If we look at Dr. Wolf's testimony, day 31 of trial, it's noted as Exhibit 10 in our package, page 36. ADA Lally asks the good doctor, now, doctor, in the course of your analysis or review of materials here, were you ever provided with a video of the defendant backing out a garage and making contact with Mr. O'Keefe's vehicle in his driveway at about 5:07 in the morning on January 29th? He says, I'm not aware of that. And then if we move to page 124, line 1. Now, line 2. Now, as far as you're aware from the review and your testing and everything that you did in this case, if a collision occurred at a lower speed, say 1, 2, anywhere from 0 to 5 miles an hour, would that create the damage to the taillight that you observed in this particular case? And Dr. Wolf says, at that speed, no. We provided notice of our own expert. And there's one thing, many things, but one critical thing the experts will all agree on. That nudging did not cause the damage to that taillight.
You're right, Hank. The nudging did not cause the damage to that taillight that you have tried to tell us looks the same as what was in Canton Police Department Sallyport. You're absolutely right, babe. It just fucking cracked it.
The defense position is also contradicted by dash cam footage. Sadly, an officer went to the O'Keefe home to check on his niece and nephew on that tragic day. And when he did, he had a dash cam video further reinforcing that that taillight is missing well before that vehicle makes it to the Sallyport area. If we could play Exhibit 7, which is dash cam footage showing Mr. O'Keefe's car in his driveway at 8:22 a.m. If you could close up from the court, please. If you compare the right side to the left side. Although
Mr. O'Keefe's car? Well, is that, I see Mr. O'Keefe's car. I see the Traverse, but do you know what you're even talking about?
impacted by snow, if you could more close up, please, you can see that taillight, just like the detective from Dayton said, just like the 508 ring video shows, is missing. Is missing. There's no plan.
It's caked on. That's what I see.
The defense's position is also contradicted by the alarm.com video that we received pursuant to Rule 17. There are 2 videos, 8 and 9. If we could play Exhibit 8, please. This is the defendant's car arriving indicted in the driveway. The defendant on the passenger
Oh.
side, and you can see them walk to the back of the car near the right taillight and stop. And if the question is, what are they stopping for? We can play video 9. This is when the car is being put on the tow truck before it makes its canyon. And just like 508,
And it was this moment, babes, that I believe that Karen Reed's Lexus SUV registers the event in question of less than 5 seconds where her tires are rotating in the snow. Not anything that occurred near 12:32 a.m. on January 29th. And Karen has always said, excuse me, sorry, babes. Karen has always said, I cracked my taillight. Was she showing? Hey, I cracked my taillight. Yeah, babe. Again, thank you for showing our case, Hank, and not doing a great job for your own.
in the driveway of Meadows, John O'Keefe's home, you will see that right taillight shine white, showing the missing taillight cover on 2 occasions. If you have an opportunity to stop the video at the important points, please do so.
Can you lower it?
You cannot.
Can you zoom in on it?
Your Honor, I would encourage the parties to look at it on the computer. The clarity is much better, and it's very clear, the white light missing video. I cannot see it clearly on the screen.
Oh, I'm getting delusional. I'm so sorry, babes. He says, I would encourage you to go and just watch this because I can't see it. Okay. Look up on the screen. I can't see shit. Thank you, Hank. Thank you.
So will you give me a flash drive of all of these exhibits?
Oh, there we go.
Oh, okay.
If you look at it on a small screen, see right there?
I do see it.
Yeah, and then you see it again.
I'm delusional.
So the alarm.com video contradicts the defendant's position that if anything is exculpatory.
Wait, there was nothing that was at the, wait a minute, wait a damn second. So he's telling us that the white light and the farthest bottom corner now piece is missing allegedly from Karen's vehicle, but next to it is not. Oh, Hank, you're so fucked. I'm going to go and get all the footage. Because the wing portion that goes onto the like rear quarter panel of Lexus's, that design was completely intact. And now you're saying that this white light is a representation of the missing piece. Oh, the defense is going to have a field day.
About these Sally Port videos. In fact, this whole idea of third party doesn't come to town until 9 months after Ms. Reed is indicted. Perhaps the best evidence that contradicts the defense's position that there's any relevance to the Sally Port video, that there's any type of plant by anybody, is from the defendant herself. Ms. Reed spoke to Gretchen Voss on June 20th, 2023. And in that testimony, or in that interview, she said, when my car was seized, there was a few small pieces of taillight missing that I had picked out at John's at 5:45 before we drove over to Fairview. I'm showing Jen and Kerry, look what I just did to my light. And I'm worried that there's gonna be some kind of electric short circuit. There's like the bulb is showing and some of the red plastic is missing. So I picked pieces out of the light housing that kind of collapsed within the light and dropped them in John's driveway. And so I say to the court, the production should have been sooner. It should have been cleaner. This should have been a log or an entry. The failure to provide was inadvertent. It was unfortunate. It shouldn't happen, but it's not Brady. It's not exculpatory. It's not intentional. It's not tampered with. It was inadvertent and inconsequential because the evidence is overwhelming that light is missing before the car makes it.
Thanks, walking the
Sally
plank.
Port, so there can be no plan. That is my argument regarding the Rule 14 issue. I would like to have time to speak about the claim of jury tampering. I understand the temperament of the court. I'm not tone deaf, but it is a claim that was
You are tone deaf.
lodged that has collateral consequence. And I think it's important for me to be able to address it. May I?
Yes.
The claim of jury tampering is probably one of the most serious claims that one can make because it's not simply an attack on a case. It questions the fabric of our entire judicial system. If a good juror
Oh.
comes to court and believes there is no integrity in the court or in the judicial system, it is impossible for a fair-minded juror to even consider evidence because they do not trust the system to begin with. And if a government actor or a trooper or a police officer tampered with a jury, that would be one of the biggest, most abhorrent transgressions that could happen. Because of the collateral consequence of tampering with the jury, it would take away the community's belief in our system. On the other hand, if there is a claim of jury tampering and it's baseless and there is no evidence, it is not only a direct
2021,
on the
Lovey.
judicial system. It would seem to be an effort to try to undermine the authority of the system in court before a trial to impede the ability to have a fair trial. It is an extraordinary claim. And it's notable, the defense motion to dismiss, it's not just a motion to dismiss, it's a motion to dismiss for extraordinary government misconduct. So when you make an extraordinary claim about jury tampering, there should be extraordinary evidence. There isn't even ordinary evidence. There is no evidence of jury tampering in this case. Now, I don't want to belabor this, but it's important because of the consequence of what happens when a claim like this is lodged. There is damage. And why
Oh, I don't know, Hank. Maybe like when you got up at that fucking podium and you said that the federal government provided you with information and emails regarding ARCA and the defense team when it was provided to you by the defense team in reciprocal discovery? Yeah. You've lodged some very serious allegations at this defense team. And if there was a trooper who was in charge of the jury, and maybe knew things, that could be a problem. And it does eat away at the fabric of our judicial system. You're absolutely right.
rather sit down, as I said before, a lie unchecked becomes a truth. And so how does one propagate a claim of jury tampering when there's no evidence? Well, first you need to plant the seed of corruption. And all you have to do is whisper and hope the poison goes out there and is resonating in the potential community. And so what happens in this case? The defense finds a willing partner who covets an opportunity to meet with the defendant. They find a time, like after the Super Bowl, so there's this national exposure, and they just seep the information. They just seep it into the public and let it resonate. There can be no retort. The government can't respond. No facts, no evidence. Just saturate the public. Now it's important to see or hear or read what is said, because this really is the acorn that is being planted that cannot be rebutted.
I did love it.
It's not insignificant that this same information before this interview is being disseminated by Mr. Kearney. This idea that there was tampering by Lieutenant Fanning, not a coincidence. And so during this interview that the defendant.
Oh my gosh. Did he say, oh my gosh, Hank, did he say that Turtle Boy was coveting, like having an interview with Karen?
They have. The question's asked. I don't know why it's asked, but it's asked. There have been sort of these unsubstantiated claims in the atmosphere that there might have been some funny business with the jurors who were dismissed. Really? And Mr. Jackson says, right. The question, is this a real concern that you have? Is this something that you were looking at, or have you just dismissed it as a rumor? Answer, I never just dismissed that as rumor. Something like that, it's too convenient for the prosecution for us to just dismiss out of hand. Do I have any evidence, specific evidence that there was jury tampering? I don't have any specific evidence of it.
So
We have a motion filed 2 weeks later.
why the fuck are you talking about it then?
Do I think there are questions that should be asked? Do I think that there are questions that have been raised about the way the jurors were dismissed and who was dismissed very specifically? And then it continues on page 13 of the transcript. Question. One of the state troopers who was involved with the Norfolk DA's office and on the periphery of the investigation was also responsible for the jury. Not sure where these questions come from. The answer, right. He wasn't that far on the periphery of the investigation. He was involved in the investigation. He was direct supervisor over the individuals that were testifying and over and about whom we had leveled some very, very serious claims and ended up proving those claims during the course of direct and cross-examination in the presentation of our case. That person, that supervisor, we found out well in the trial. As a matter of fact, at the end of the trial, we found out is the very person who was governing the jurors. That's a question that should be raised. That is an issue that should be teased out. Should never, ever happen. That is the very definition of a conflict of interest. Question, is that standard in Massachusetts for just the DA's office to assign whoever they want to be sort of, supervisor of the jury? Yeah. Is it standard in Massachusetts? I hope not. Never seen that in my life. But if I had a nickel for every time I said I've never seen this type in my life as it pertains to the Massachusetts justice system, the criminal justice system, I'd have a lot of nickels.
So I didn't see that interview. I don't have the transcript. I'd like a copy of that transcript.
Your Honor, I understand I made a mistake and we produced all of the exhibits to the court and you should have a transcript. If not, I'll get it to you immediately.
Okay.
So after step one, finding a vehicle to plant the seed, and they did that.
A
very effectively.
vehicle to
The next
plant
step
the
is they identify
seed.
a target. Who are they going to blame? Who's going to be the villain? In this case, a villain goes from anybody that gets in the way. It could be a soccer mom. It could be a police officer. It could be a good Samaritan. Anybody that crosses the path is a target. And now they decided they were going to identify Lieutenant Fanning. Lieutenant Fanning is one of
Guys, we know who Hank Brennan has been watching. Okay. Thought it might have been one of us. No, a soccer mom. Who calls a Jennifer McCabe the soccer mom? He's in the cottage, guys. He goes to the yellow cottage. That's an interesting choice. I see where the logic comes from.
the most conscientious, dedicated, admired state police officers in Massachusetts.
Wow. Oh, the same ones that can't investigate another a police officer in Stoughton who murders a 23-year-old pregnant woman who he groomed
After having-
since she was 15. Those respected, decorated, incredible examples in our state. Fuck off, Hank.
his name attempted to be sullied all over social media, attacking his integrity and his name. I can dare say that Lieutenant Fanning is in a different position than many. His integrity is so reputable, none of that will break him or his reputation. But it happened. When you look at the motion filed by the defense in this case, and they found their target in Lieutenant Fanning, you look at this motion, page 15. It's important when they made this public pleading, getting back to my request, Your Honor, the other day. You look at the bottom of page 15. It talks about Lieutenant Fanning and tries to align him or associate him with Trooper Proctor because Trooper Proctor's text message was on a chain that included Lieutenant Fanning. Lieutenant Fanning did not reprimand or otherwise correct his subordinate's disgusting and inappropriate behavior. As a result, he was investigated by the Office of Professional Integrity and Accountability for allegations of inappropriate correspondence between department members. True. But then they leave off the punchline. They put this in a public document. They try to smear him, degrade, demean, dehumanize. But what they leave out is that after this thorough investigation by the Office of Professional Accountability, where they took strong measures, very strong measures when they found something that they were not in agreement with, they concluded that these complaints were not sustained.
So we were all aware of that. I received.
Yeah,
notification that
everyone
the
has.
Prosecution
Thank
Council was all
you.
aware of that. I just need the date. When was he cleared? When was that made public?
We'll have to provide that to you.
Was it prior to this? Was it prior to the motion being filed?
Yes.
Yes, it was last year, last fall. I can provide the date right now.
Okay.
Trooper Lieutenant Fanning is not in a unique position.
If I may, Your Honor, sorry. It was July 17th, 2024.
He is similarly situated to the many first responders and witnesses in this case. And then, without
That was Matthew Farwell, Lovey.
any basis, the defense then distorts that Lieutenant Fanning was in charge of juror security. He had control of the jury, and he had access to the jury. Think about what those statements say to our community. We're going to pile in here in less than a month to try to give a fair trial to both sides. Think about what those words mean.
Holy moly. That's all I'm going to say. And if you know about Kevin Clapp and his interviews, Truth and Transparency did an incredible interview, and Dave Cullinane did a 4-hour interview with Clapp regarding Sandra Birchmore. And it was shocking, to say the least. But as I said, when I heard, holy moly, if you know, you know.
After selecting their target and trying to dehumanize him and degrade him, they then try to create an illusion of this grandiose havoc that is running amok. trying to get the community to think Trooper Fanning controlled, had access, and tampered with the jury. Think about that concept. Not only is it an attack on Lieutenant Fanning, it is an attack on the integrity of the trial court. I've walked a lot of hallways in the trial courts over the past 30 years.
He said, are you going to let him spit in your Kool-Aid? Are you going to let this defense team just pee in your Cheerios, Polly Pocket Bev? No.
And the heartbeat of trial courts is the court officers who take their duty so seriously. They help.
Oh, like in the $500,000 that it cost for trial 1 in Mass State Police overtime budget? Oh, there was a lot of money to be made by Mass State Police in Commonwealth v. Karen Reed. And Ted Daniel gave us all that info right after trial.
They assist, they guide, and they have solemn pledges. They are charged with the responsibility of the jury. To suggest this is to suggest that the hardworking men and women in our trial court system who come here every day for everybody else's benefit, it is to suggest that they would cede their authority to the state police and abscond from their duty and responsibility to protect that jury with no basis whatsoever. That is the concept that they are promoting in this motion. The trial court person.
Babes, I'm so sorry, but I'm fading. It's 12:30. We've done this. We've done 2 hours. I am going to do the rest tomorrow night. Okay? I love you. I apologize, but we're going to get through. I will start exactly at the 141 mark, and then we will do like questions and answers together. But I wanted to get through 100% that bombs that were dropped, the Hiroshima style, by AJ. His incredible oral argument and the delectable breadcrumb that was given to us by Judge Beverly Cannoni when she acknowledged for the first time ever in Commonwealth v. Karen Reed that a lesser remedy would not fix the prejudice and or presumed prejudice towards defendant Karen Reed. I have to work tomorrow. You have to work tomorrow. And we're going to come back together. We're going to hold each other's hands, clutch our pearls, and get through the rest tomorrow. But this was a day the Lord had made. Let us rejoice and be glad. Okay? For all of you who got your ashes today, I'm so happy for you. Let's start this season off right. And I believe that today really has Karen and the defense team in a position that I could not have foreseen. That discovery dump and the actual foot in mouth that Hank Brennan has somehow managed to do is going to be reviewed by Judge Cannoni. And I really, really believe that if we had a 0% chance previously that she could dismiss anything, I feel like we might be at a 10% now. If we were at a 20, maybe we're at a 40. But I am hopeful. I am optimistic. And I am always on the side of justice and truth. And I know you are too. So now let's say goodbye to the person who should not have a job. And on his March 13th hearing, perhaps he will be let go finally. The one, the only, Chip Proctor. Chocolate Chip Proctor is what they're going to call him in the pen. Okay? On your mark, get set, punch a Proctor. All right. Mwah. I love you guys so much. Have a good night. Rest your bodies. I'll talk to you tomorrow. Bye.